Property law questions. Let's get started. In a deed that states, to Jonathan for his life, the grantor has what type of interest? Is it A, life estate? Or B, remainder? Could it be C, reversion? Or lastly, D, right of re-entry? The correct answer is C. Here is why. When a grantor conveys a life estate to Jonathan for his life, they have not conveyed the future interest. The property will return to the grantor or the grantor's estate upon Jonathan's death. This future interest retained by the grantor is called a reversion, C. A remainder, B, is a future interest given to a third party. A right of re-entry, D, is associated with a condition subsequent in a defeasible fee. Next question. Fee simple is all of the following except. Is it A, an estate of inheritance? Or B, a freehold estate? Could it be C, a less than freehold estate? Or lastly D, indefinite as to its duration? The correct answer is C. Here is why. Fee simple is the highest form of ownership. It is an estate of inheritance. A, can be passed to heirs, a freehold estate. B, ownership estate, and indefinite in duration. D, lasts forever. A less than freehold estate, C, is a leasehold or tenancy, not a fee simple ownership estate. Next question. A hospital receives a gift of real property from an elderly couple who reserve to themselves a life estate. The hospital is the. Is it A, grantor? Or B, remainder man? Could it be C, reversionary party? Or lastly D, donor? The correct answer is B. Here is why. The elderly couple are the grantors/donors. They have conveyed a life estate to themselves, life tenants, and a future interest to the hospital. The future interest that takes effect after the life estate ends is a remainder. The hospital, as the recipient of that future interest, is the remainder man, B. Next question. Which of these activities can the owner of a life estate not do? Is it A, sell? Or B, mortgage? Could it be C, devise? Or lastly D, lease? The correct answer is C. Here is why. A life estate holder, life tenant, can sell, mortgage, or lease the property, but only for a period that cannot exceed the duration of their life estate. However, they cannot devise, see, leave by will, the property to an heir because their ownership interest terminates upon their death. The future interest, reversion, or remainder, held by another party becomes possessory at that moment. Next question. A widow who has willed the use of the family home for the rest of her natural life, with provision that title shall pass to the children upon her death, holds. Is it A, a fee simple estate? Or B, a leasehold? Could it be C, an easement? Or lastly D, a life estate? The correct answer is D. Here is why. This is a classic example of a life estate, D. The widow, life tenant, has the right to use and possess the property for her lifetime. The children hold a future interest known as a remainder. Upon her death, the life estate ends, and the children, remainder men, automatically receive full title in fee simple. Next question. A life estate may be granted. Is it A, only when it is for the duration of the grantee's life? Or B, for the duration of the life of someone other than the grantee? Could it be C, for a definite term? Or lastly D, only to a grantee over the age of majority? The correct answer is B. Here is why. A life estate is measured by a life or lives. It is most commonly for the life of the grantee, the life tenant, but it can also be measured by the life of another person, B, which is called a life estate per autre vie, for the life of another. It is not for a definite term, C, like a leasehold, it ends upon a death. While practical, it is not a legal requirement that the grantee be over the age of majority, D. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe, and tell me what topic I should cover next. Bye.